I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your boy TP. Guess what? We are courtroom hopping into 4 different courtrooms today. Yes, we are back with another compilation video. Thank you guys for all of the encouragement. I am happy for you guys that haven't seen some of these cases that we've posted in the past. And that's why I am doing the compilation videos, because some of you have not seen, especially some of our new subscribers. So with that being said, let me give you the lineup so I can get out of the way. You know that there will be no commentary at the end. There will be chapters involved in these videos, just in case you have seen one of the proceedings. That way you can skip to the next. With that being said, the first courtroom that we're going to be in is going to be Judge Gauthier out of the state of Michigan. The second courtroom we're going to be in is Judge Perkins, also out of the state of Michigan. Third, we will be in Judge Robinson, also out of the state of Michigan. And we know Michigan is just, like a sovereign citizen society out there. We get so many cases from there. But lastly, we will actually be in Judge Wilcox's courtroom out of the state of Washington. So with that being said, guys, thank you once again for joining me here at Sovereign Citizens Hall of Fame. I hope you guys enjoy these proceedings. And until the next time, guys, thank you and God bless.
Well, Mr. McLeod, it's alleged that you are in contempt of court for failing to appear on July 9th at 9:30 a.m. for a 50-page report hearing. You've got the right to a hearing on that allegation where it would need to be proven beyond a reasonable doubt, and the right to the assistance of an attorney at that hearing. If you are found to be in violation, if you are found to be in contempt, I could jail you for up to 93 days. I could fine you for up to $7,500 or both. I can also revoke your bond if you're not complying with the terms of your release. Do you understand the rights and penalties that you have in front of you, Mr. McLeod?
Sure. I was under the impression that this was all going to be over with by now. That we're
Nope. Nope.
agreement.
All right, Mr. McLeod, and also, so you know the rights and penalties that I outlined for you. You understand those?
Yeah.
All right, Mr. Barger, do you know how he wishes to proceed?
No, he indicated he would enter his own plea.
Mr. McLeod, you're indicating you want to represent yourself?
Well, I thought that can I say a couple things first?
No.
Okay.
You can answer my questions.
Sure.
Are you saying you want to represent yourself?
They have been doing that the whole time.
You've been doing that the whole time. Under Ferretta v. California, 1975, U.S. Supreme Court, defendant has the constitutional right to represent himself. He has, in this case, unequivocally asserted that right in prior hearings and validly waived his right to counsel. However, self-representation may be denied where the defendant disrupts, unduly inconveniences, or burdens the court and the administration of the court's business. That's 1976, Michigan Supreme Court, People v. Anderson. Even the Ferretta case, the U.S. Supreme Court said the right of self-representation is not a license to abuse the dignity of the courtroom. Neither is it a license not to comply with the relevant rules of procedural and substantive law. Here, while representing himself, defendant refused to accept mail from the clerk's office. When that happened, I directed staff to resend the mailing directly from the court, giving him the benefit of the doubt. Because he was representing himself, he would surely accept something from the court. He again refused, writing in red lettering on the envelope, return to sender, and offer to contract is denied. Defendant had someone file a document on his behalf in his case called a letter rogatory for relief, which was legal nonsense, accusing the court of fraudulently using this case as some sort of security against his trust, claiming that all judges are foreign agents and or employees of the International Monetary Fund, which is absolutely absurd, and demanding that he be placed on some non-existent do not detain list. This is not the first time that this defendant has disrupted this court's business. One time I had to hold Mr. McLeod in contempt for refusing to answer my questions during his initial waiver of counsel. After that contempt, we were able to complete the waiver process and I allowed him to represent himself. But at those subsequent hearings, he repeatedly interrupted the proceedings. He repeatedly persisted in arguments even after being heard and ruled against, and now he has refused to participate in the court process by rejecting court mailings while purporting to represent himself. So I have now lost any confidence, Mr. McLeod, that you are able to represent yourself in this matter without disrupting the court's business or making a mockery of the court proceedings. Therefore, as this case moves forward, I am revoking your right to represent yourself, and I'm appointing Mr. Wirgo to represent you as a lawyer.
Okay, it's Mr. Wirgo here.
If the office of assigned counsel determines that Mr. McLeod is not indigent or is only partially indigent, that office may petition this court under the applicable statute for contribution from Mr. McLeod for the cost of representation. So, Mr. Varga, you want us to set this for a hearing then?
I do.
All right,
I do plead not guilty.
all right, Mr. McLeod will enter a plea of not guilty on your behalf as to the contempt. So we have to schedule this for a docket call on the underlying case, which is still pending, and on the contempt hearing. I'll schedule that for August 20th at 10 a.m. I also have to advise you, Mr. McLeod, that I canceled your jury trial date and gave that date to somebody else who was here. So your trial on August 8th and 9th will not occur. I will next see you on August 20th at 10 a.m. Anything as to release Mr. Varga?
Is the court willing to entertain a bond on this matter, Your Honor? To my understanding, Mr. McLeod is a local resident and he has met, with the exception of the last court date that he tells me that he thought the case was resolved, although obviously it was not. He has appeared for most of his prior court dates.
Oh,
Okay. And he's employed locally, Your Honor. I think perhaps if the court would set a modest monetary bond, that would ensure future.
I will not have to do. Make sure.
Mr. Juliet?
And I would ask that bond remain revoked. He is, what I'm told, rejecting the court's mailings of the notice to appear. I mean, I think that's just a blatant violation of
Can I speak on that?
the court rule. So he's made it clear he doesn't want to take it as serious. I would ask that bond remain revoked.
All right, Mr. McLeod, is there something you wanted to tell me?
I wanted to speak on that, the mailing stuff. I do that with all my junk mail, and I'm really sorry if that happened to one of your letters.
Don't make it worse by lying to me right now, Mr. McLeod. You wrote clear things on that mailing that indicate sovereign citizen types of defenses that you thought you were asserting. It's not that this was junk mail. Don't make it worse. Don't make it worse by lying.
I apologize to you for maybe listening to some of the wrong information when I don't.
Well, you're a grown person, Mr. McLeod, and I hope you're learning an important lesson in civics.
Can I just say this?
You said what you wanted to say.
Before you make your decision, can I say this? I have a job right now that's completely exposed to the weather. I've got $40,000 worth of windows coming this week to this job. I really invested in this job, and my client really relying on me. This would be a really big problem if I get this revoked at this stage.
All right, well, Mr. McLeod, it's a shame you had to learn a civics lesson the hard way here. You are a citizen with rights and freedoms, but you also have responsibilities in a society where other citizens live alongside you. That includes obeying the laws that the people pass through their representatives. For example, the people are entitled to pass a law that says they don't want folks operating boats under the influence of alcohol. You think that law doesn't apply? It does.
That wasn't.
And when a law enforcement officer sees you violating that law, you can't resist arrest without consequence. When you are alleged to violate those laws, Mr. McLeod, there's a third branch of government that does exist. And it exists for the orderly resolution of those disputes, those allegations, with full protection of your rights, as opposed to some kind of vigilante justice system. You may not agree with this, but this court has diligently tried to protect your rights and afforded you a respectful and lawful process. You have disrupted and ignored that process. You have disrespected that process time and again. That subjects you now to contempt of court and revocation of bond. Most people, Mr. McLeod, learn this lesson the easy way, but it seems that you now have to learn it the hard way. You're remanded into custody of the Showdown County Sheriff, and will next see you, sir, with your lawyer, Mr. Wirgo, on August 20th at 10 a.m.
What is your date of birth, Mr. Gray?
Good afternoon, Your Honor. 72 is my date of birth. I have a
you say that again? Go ahead and say what you were about to say.
I have a motion before the court, Your Honor.
Let me first start. Do you need a lawyer, sir?
No, Your Honor.
City of Detroit versus Christopher Gray. State your name for the record, please.
Christopher Lamar Gray.
All right, today is the date and time set for a pretrial, and then there's warrants on the other matters. I'm gonna enter a not guilty plea on your behalf. I'm gonna give you a $0 bond. And I'll recall the warrants. What is your motion, sir?
I have a motion to strike and dismiss.
What are the bases?
Basis of federal rules of civil procedure. Number one, there's no claim. There's no ratification of the claim.
There is a claim. There is a. You want me to read out I waived the reading of the information. You want me to read the allegations that have been made into the record? Do you need me to do that?
No, I don't. No, I don't, Your Honor.
I deny your motion on that basis. What else do you have to say?
What else? You deny my motion because of what, Your Honor?
Yes.
There is no real.
I denied your motion because there is a and this is criminal procedure, not civil procedure. But I denied your motion because there is an allegation here.
You're saying, Your Honor, you're saying this is a criminal matter?
Yes.
Okay, well then we need the corpus delicti. And so that's what I'm asking for. If there was a criminal matter, basically what you're telling me is that something has happened, someone has either been damaged or someone has been or either someone has been damaged or someone has something has been come up missing. And if that's the case, then that means that there is a crime. And if there's a crime, then there is the what do you have that's saying that I did the crime? What you're saying that I created this crime that hurt this person, and if I hurt this person and I created the crime, then a third thing that you have to have is the identification of the person. You have the identification of the person, which is me, but you don't have a person saying that they were hurt or damaged, or the crime that's saying what I did to hurt or damage the person. So how do you have a crime?
Okay. You went to law school?
No, Your Honor, I have not.
And where did you get that? Where did you get that from? Where did you learn all that?
I've been studying for quite some time, trying to understand what's going on. I have a different perspective as to what's being said that happened. I'm understanding more the procedure that is necessary for a crime to go forth, for them to bring a crime forward. I'm understanding that a bit more.
And where did you get that understanding?
I've done some Cornell law studies. I've also sat down with a couple of friends who have had some issues. I picked up wherever I could, just started to study the law. I just started to go back through Cornell law, started to figure out what was going on, and to understand the nature of how what a crime is, and everything else. So just a course of me searching it out.
And you're citing Cornell law for all of that you just said to the court?
No, what I did, Your Honor, was I realized that one of the biggest portions that you have to have is you have to have the corpus delicti. And that is in when you're being charged criminally.
What is a corpus delicti?
What do you mean, what is the corpus delicti?
What is your understanding of what corpus delicti is?
That is the corpus delicti is the law that's saying that there is a crime that's being committed. So in order to do that, you have to show the corpus delicti, which is you saying this is what happened. This is how this person was damaged.
So,
there is no
the
person.
Officer on these dates, because I got a lot of them, said that
I object.
Don't
The officer
interrupt.
works.
Don't interrupt
Okay,
me.
I
Don't
apologize,
interrupt.
Your Honor. I apologize, Your Honor. My apologies.
Officer says that you drove a vehicle that wasn't registered and wasn't titled, or titled and or untitled, that you drove without a valid driver's license, that you drove without valid insurance. Again, on a different occasion, they allege that you drove without a valid driver's license and no insurance. And then on a different occasion, they allege that you drove without unregistered or untitled, or both, and drove without a valid driver's license, repeat offender, that you failed to have a trailer plate, and that you failed to secure a load on your vehicle. And on another occasion, on the same occasion that you failed to secure, that they allege you failed to secure the load, failed to have a trailer plate on your vehicle, that you didn't provide a valid driver's license. So those are the crimes. And in state of Michigan, whether you agree or not, they are crimes. So based on your motion and all of that stuff you talk about, corpus delicti and things like that, the court denies the motion. Okay, based on those reasons I just said. Now, how do you want to move forward? Because wait a minute, I'm not finished.
My apologies, Your Honor.
How do you want to move forward? Because in my experience, someone that comes into court, as you do, you do not want to take an offer. You do not believe that you need to have plates or registration or insurance. And you just disregard all of that portion of the law, and either you are going to move forward by having a trial, or you're going to take a deal. What do you want to do, sir?
Your Honor, first I want to put my objection on the record. And at that point,
whatever your objection is noted. What do you want to do, sir? Do you want a trial? You have two options: trial, or you want to take a deal.
Your Honor, I request a jury trial.
A jury trial.
A jury trial, yes, Your Honor.
Very good. Ms. Mathis, I need a jury trial date. Please.
And if I may, Your Honor, what time is Mr. Gray presently docketed?
I don't even think it matters, but I'll tell you. I don't think it matters. He's got the newer cases and the older cases are pre-trial at 8:35. Christopher Lamar Gray, and then he had some in warrant status. I counted 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 cases into the record. You know what I want to ask, Mr. Gray, and you can choose to answer it or not.
Yes, Your Honor.
But what I surmise and what I've heard, and I don't know if you're alleging the same thing, is that and you basically did allege the same thing, that no crime has been committed because no person has been, the people of the state of Michigan are in danger of you driving without the proper documentation or anything like that. But I don't, and I'm gonna surmise, and you can correct me if I'm wrong, that you're gonna say that there's no jurisdiction to be able to pull you over because no one has been injured. Is that correct?
I think that what I'm saying is that the city of Detroit had an officer pull me over to say that you're not following these rules. And my stance is, okay, well, then that's fine. If we're following rules, then therefore, let me make sure that you as well as are following the rules, because if I don't do that, then freedoms are lost. So that is that is the way that I proceed, to say, okay, well, then if we're playing cards and we playing show me yours, if this is your hand, then this is mine, and let's proceed accordingly to the law. That's it. That's my only standing, is if someone doesn't stand up every once in a while and define the edges, then they all disintegrate and people lose rights.
And you know something? With that being said, I would agree with you 1,000%.
Mhm.
That's why I pride myself, and I hope I'm doing a good job for the citizens that come in here and the police for that matter and the prosecution, that I am calling the balls and strikes right. And if something doesn't proceed as it should, then I will dismiss the case one way or the other. But in my short time on this bench and in my time at practicing law as a defense attorney, I get this, you know, they can't pull me over. I've heard the corpus delicti, first time the civil procedure has been thrown at me. But from my understanding, from the way I see it, is that you just don't feel that the police have a jurisdiction to pull you over for these issues. Is that correct?
Do I have the, what, again, Your Honor, what I feel is that if we are following rules, that if I have to follow the rules and every person out there, all of these officers, everybody else has to follow the rules. So if it comes down to it,
what I'm gonna hope that you do by the
Your Honor.
time you come back on the trial date, this jury trial date is gonna be strike that, March the 18th, 2025.
Thank you, Your Honor.
You're probably gonna have an audience because everybody follows me on these cases all the time.
I understand.
All right, and I don't know if that's what you want, but we're gonna do that.
It's not that.
March the 18th, 2025. We're gonna have a final pre-trial date. Final pre-trial. This is to you, Mr. Bowman, especially the day before on February 17th, 2025 at 8:30. So Mr. Gray and Mr. Bowman, Mr. Bowman, I need you to have all your officers appear on that date. Who's ever going to state these allegations, so that we know that we're not just summoning the people of the city of Detroit to a jury that's not actually going to go. So all parties must appear, and that can be via Zoom. And the trial is going to be in person. All right. All parties must appear on final pre-trial date and obviously on the trial date. And what I would implore you to do is you need to figure out the right game, because it doesn't sound like you're playing the right game.
I understand, Your Honor. I appreciate, first and foremost, let me say, I appreciate the dialogue. I appreciate you sitting here and engaging with me at this level. So I recognize what you're saying, and so I guess it's to the table we go. So
yeah, but get your game in order, because I'm just giving you a little heads up. If you come in with that game on the jury trial date, then more than likely you'll lose, unless you can find one of those jurors or a couple of those jurors or even all of them to have some sympathy for you, sir. I don't know.
I got a whole basis for understanding, and so yeah, if you know it
that basis that you outlined shortly today is not.
What was flawed in my what was flawed, Your Honor? What is
we already discussed it. We already discussed it. The federal rules of civil procedure that you brought up as a motion to dismiss, not the right basis. The corpus delicti, they do have a corpus delicti. They do have a crime that they say has been committed. And if you read the MCL, the Michigan court rules, and the Michigan statutes, then you'll see those crimes outlined there. They have them on the tickets. They got the statute numbers that are on the tickets. So that's not the right basis. So you're in a whole different ball game, and you need to come on to this ball game here.
Okay. All right. Okay. Well, I guess we will have that discussion again. I appreciate it. I also want to say I recognize and honor your compassion that you sit on the bench with. I see it. as you go out here and you judge our people. And so for all of that, kudos, man. That's for where you sit. I appreciate that. Thank you, sir. Appreciate it.
I appreciate
Yes,
that.
sir.
Mr. Gray,
Yes, sir.
you have a
Yes,
safe
sir.
happy holiday season, sir. And
You as well.
best of luck to you. I'll see you back on March the 17th, 2025 at 8:30 for a final pretrial. And let me say this, let me add to
Yes,
the
sir.
record.
Yes,
If there's
Your
any
Honor.
motions, if there's any motions, those motions need to be in
10
writing.
days, within 10 days.
Let's put that on the record to a motion. Those motions need to be in writing. Have those motions to the court by February 14th, 2025. And the response will be February 21st, 2025. And I'll rule on those motions on the final pretrial date of 3/17/2025. Again, all
Thank you,
parties
Your Honor.
must appear, Mr. Kaufman, all right?
We are on the record with file number 22-186783, J.P. Morgan Chase Bank versus Marcus Campbell, date and time for pretrial appearances.
Good morning again, Your Honor. Jim McCardle on behalf of J.P. Morgan Chase, P number is 82443.
And your name, sir?
Name for the record is I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendant, virtually none of which I understand. So that's, as far as I'm aware, what the status of the case is.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just said I answered. I sent the brief.
I asked you if you received his motion for summary disposition.
Yes, I have.
Okay, so then I'll just calendar it. That's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something.
What
I
is
did
that,
respond. I did respond to the courts and to the complainants.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of the public to bring this to me.
Sir, you can file whatever motion you want. Right now, I'm going to calendar Mr. McCardle's motion for summary disposition. That if you want, you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock. We are going to call file number 22-186783, J.P. Morgan Chase versus Marcus Campbell, date and time for a motion for summary disposition. Could I have your appearances?
Of course, Your Honor. Jim McCardle appearing on behalf of J.P. Morgan Chase.
Bar number.
82443.
And your name, sir?
Marcus Campbell and special appearance.
Mr. McCardle, this is your motion.
Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22. And then we subsequently filed our motion for summary disposition on 12/15/2022. A series of responses, as it were filed, the last of which is a response to plaintiff's counter defendant's motion to strike, in which the defendant has a number of things, but the chief among them, in paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. And then in paragraph 8 in our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge, there's one other thing. He suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our clients, so my client corporation is not acting without an attorney, so that's irrelevant. So basically what I'm asking for is judgment in the amount of $18,610.79, in essence, because the defendant has agreed that he owes the money.
Mr. Campbell, your response?
I disagree, and I'll stand on my brief.
And you stand on your pleadings? Okay.
Which was
all right. The court's prepared to move forward in this matter. This is a motion for summary disposition filed on behalf of plaintiff and notice for hearing today. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that date, the court register of action does not appear that any pleadings were filed by the defendant. Michigan Court Rule 2.116 G4 is relevant here. A motion under sub rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. When a motion under sub rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there's a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. No response was filed to the plaintiff's motion for summary disposition. However, in his earlier pleading, which is really not relevant because they were not, again, filed in response here, the defendant admitted that he owed the money. So that's going to be it. Court finds there's no genuine issue of material fact. Plaintiff is entitled to summary disposition as prayed for under MCR 2.116 C10. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days today in the Wayne County Circuit Court. We are on the record. We're calling file number 22198-398. The file is entitled Portfolio Recovery Associates versus Marcus Campbell. Your appearances.
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722.
And what is your name, sir?
Marcus Jamel Campbell in special appearance for.
In special appearance for what, sir? You filed an answer here. All right.
Marcus Jamel Campbell, special appearance.
First thing I want to know is Mr. Kirshenheiter has filed a motion for summary disposition. Did you receive that motion, Mr. Campbell?
I'm not sure if I have, but I'm wondering if you all have my paperwork. I'm not sure if I did.
I have a motion filed by Mr. Campbell. My question is, did Mr. Kirshenheiter, did you receive his motion?
I perceive so.
Okay, so you got the motion for summary disposition filed by the plaintiff. Mr. Kirshenheiter, did you get the motion filed by the defendant?
Your Honor, I'm not exactly sure what we received. It just says brief and memorandum of law.
Yeah. Okay, that's fine. We have that. Now, Mr. Campbell, my question to you is that your answer to the motion for summary disposition?
Yes, it is.
That is your answer?
Right.
Okay, so then neither side wants any discovery, and all I need to do is calendar your motion. Is that what you're both telling me?
Yes, as long as
okay, here's what we'll do. The court will calendar for May 1st at 11 o'clock, plaintiff's motion for summary disposition. We will receive Mr. Campbell's pleadings denominated brief and memorandum of law and proof of service as the answer to that motion. This is 22-198-398 Portfolio Recovery Associates versus Marcus Campbell. Date and time for a motion for summary disposition. Could I have your appearance?
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir?
Marcus Campbell in special appearance.
Mr. Werber.
Yes, Your Honor. Today's the date and time set for plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was a Care credit card issued by Synchrony Bank. It was opened up on November 29, 2018. As the invoices attached to the motion reflect, the last payment made on this account was June 30th, 2021. At the time of charge off, it left a balance of $3,171.94, the exact amount the plaintiff filed the lawsuit for. Those monthly invoices were all mailed to the defendant at his current address, which he placed on his answer and his response to the motion for summary disposition. Defendant made payments on this account for almost 3 years and has not shown that he ever objected to those monthly invoices that he received in the mail. He filed a general denial answer and a lengthy response to plaintiff's motion, but neither provide this court with the genuine issue of material fact or a true defense to this motion. So plaintiff requests that the court grants its motion for summary disposition today.
Mr. Campbell.
Yes.
Your response, sir.
I sent a brief regarding the denial.
Yes, the court had the opportunity to read your brief. And I thought it was an interesting set of matters that you set forth here. But I'm prepared to rule on this matter. Is there anything else you want to say in addition to what was filed?
Right. I have not contracted with them, and I do not wish to contract with them now. I just want to make sure that the brief is on the record, though.
I see your brief and memorandum of law and proof of service.
Yeah. So all of that is on the record.
I see it's filed here, and I see all.
That's all I know.
I know, for example, that you cite federal rules of civil procedure. I know, for example, that you cite 28 USC 2403. I further note you cite MCR 2.614. Okay, I'm prepared to rule. Having had an opportunity to read the pleadings both by Mr. Werber and by Mr. Campbell, the court is satisfied that there is no genuine issue of material fact. The motion for summary disposition under MCR 2.116 C10 will be granted. I'll send you gentlemen out of order. Did you attach an order, Mr. Werber?
Yes, Your Honor. There is an order attached to plaintiff's motion. It's right before all the exhibits.
I see it. I see it. All right, the court will enter that today. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court.
So, Mr. Valentine, would you unmute, join us, or I should, if I remember correctly, you'd like to be referred to as American National Valentine?
Present.
Okay, and is that how you'd like me to refer to you?
Yes, ma'am.
Okay, I don't remember that. So, sir, there was a warrant issued for your arrest back December 6th. You had posted bond on the previous warrant. We had a hearing, and that's what we're here about. Is we're still pending trial. And you weren't, the pretrial services violation. That's right. We've got a positive UA from November 1st for THC and cocaine, November 20th, a dilute one, but concerned about THC and cocaine, November 22nd, a UA positive for cocaine. So that's why we're here today. And I remember in the past that you were representing yourself. Is that still your intention?
Yes.
Okay. So let me turn to the status to this warrant issue, and then I'll turn back to you and Mr. Weston.
Your Honor, this time the state would be asking that the current bail be increased to $10,000. It was previously, the state previously asked that amount at arraignment. The court previously imposed 15,000. That somewhere throughout the process, the court decreased the bail to 5,000. He posted the bond for that amount, and which I believe he was released on October 29th. And within a month, we have all these pretrial violations. And so the state has substantial concerns about him not following the release conditions that he's required to follow, especially being on pretrial release for DUI. And so the state's asking that the court impose $10,000 bail at this time, and that he either posted or turned himself in.
So, Mr. Valentine?
So I object the state motion. The release conditions that were set were not returned. Ooh.
I can hear you. I can.
Okay. Yeah, the release conditions that were set were not returned to its original state. The release condition only changed because the 3 charges were added. And once the 3 charges were dismissed, our release conditions were supposed to be returned to personal recognizance. There was other individuals when I was in custody that were in the same situation. The state brought charges against them, but the state didn't have the physical evidence yet, and they released those individuals on their personal recognizance and waited for the results, for the evidence to pursue those charges. But with me, the state is being prejudiced and tried to keep me with strict release conditions, even though the charges were dismissed.
I'll come back to you, Mr. Valentine, but let me ask that particular question of the state here. So is the state ready to go forward to trial? You have all the evidence, all the discovery on this matter, or is there toxicology reports that are pending, or?
Based on my knowledge, Your Honor, there's no blood draw in this case. The state is ready to proceed. It was American National Valentine that did request the continuance of trial confirmation on 11/8.
So you've got everything.
We got everything.
Tox reports. Okay. All right. So back to you, Mr. Valentine. Anything else? I'm sorry. American National Valentine.
The state was awaiting the toxicology report for case number 4A0027328. Those 3 charges that were added on to the case was the reason why I was on the ankle monitor and working with friendship services. And so since those charges were dropped, I'm only on the case for my DUI, my first DUI. I never had any previous DUIs. It's my first DUI. I was only brought into custody for the extra charges that were added on, and those charges were dismissed. But the release conditions were never changed. So even my bail, they didn't even lower the bail. I had to argue with the court just to get the bail lowered, even though the charges were dismissed.
So this one is alleged from November 13th of 2021. And then I see that there was a January 1st of 2024 that was dismissed. And now it looks like that has been refiled with an arraignment date scheduled for January 14th. Don't know if you've gotten that in the mail yet or not.
I have.
Okay,
yes, I have.
So, all right. So you're right. These conditions are only about the case alleged from November 13th of 2021. Gotcha. All right. And that's the court order on that matter. 1A730693 was the pretrial services requirement and the requirement of sobriety. All right. So you're saying that, and tell me if I'm wrong, you're saying that I should release you, set this on for trial, and what about conditions of release?
So the conditions to release, I should be back PR'd as I originally was with this charge. If on the other case, like how you said the case was refiled, it's going to be in January. If the state wants to set release conditions for that charge, that should be done on that case, but they're 2 separate cases now.
All right.
Does that make sense?
Yep, it does. And there was All right. I guess I don't agree with you. There was a request to October 28th to change the release conditions, and that was denied. I guess that was me from the court's docket. That's what I'm reading. And so that was considered already, and that was denied. So, and now I have these allegations from pretrial services. So, all right, Mr. Valentine, we've had difficulty with getting compliance while you're on release. We've had difficulty with getting into court. And so I am going to increase that bail amount to, because 5,000 apparently isn't working. And I don't know what else to do. Pretrial services supervision isn't working. And so at this stage, a 10,000 cash or bond bail needs to be posted. You're appearing on Zoom. So either post that 10,000 cash or bond bail by Friday at 3, or you're in custody by Friday at 3. So you make that decision. And then we'll have a hearing on, I'm going to set this, it's going to set everything for that January 14 day. And so that we've got everything together. What time that is, but you either, as I said, it's 10,000 cash or bond bail to be posted no later than 3 o'clock on Friday the 20th, or you're in custody by Friday the 20th at 3, no later than 3. But we'll set this hearing. The next hearing will be January 14th at 2:30. It's a pretrial. So, any questions about your obligation there?
Yes. What are the nature and cause of these charges?
Driving under the influence. You're charged with and driving while spending the 3rd degree. The complaints are in the court file.
And what is the criminal jurisdiction like? What's the nature of the causes? Is it under admiralty jurisdiction or common law jurisdiction?
No. Washington State, RCW 4661. Violation of the state law. You're in Thurston County District Court, which has jurisdiction over you, as it's alleged to have occurred in Thurston County.
But I'm asking, what's the nature and cause of the charge? Is it under a common law? Is it under common law or admiralty?
It's under Washington state law.
Don't you have the duty to make the nature and cause clear to me, ma'am?
I have.
Do I not have a right to know the nature of the cause?
Yeah, and I have. And you can put it to writing if you think there's something more. A bill of particulars might be something that would be useful to you to send to the prosecuting attorney's office. But
I requested a bill of particulars. I've requested a bill of particulars, and I've requested the case transcript, and I've gotten neither.
Yeah, it's not going to be transferred. There's nowhere to transfer it. You're in the correct jurisdiction. You're in Thurston County District Court.
I said I asked for a case transcript. And a bill of case transcript and a bill of particulars, and I still haven't gotten it.
All right, we'll follow that up with the prosecuting attorney for the bill of particulars, and then the transcript. That would be from the court if you wanted an audio recording of the proceedings. All right, so
still haven't made clear the nature and cause of the charges, ma'am.
All right, well, I think I have. So you're to turn yourself into Thurston County Corrections no later than tomorrow by 3 p.m. or you can post 10,000 cash or bond. We'll have our next hearing January 14th, 2:30. And you stay clean and sober and law abiding, and you're still on pretrial services supervision if you're out of custody and you comply with them.
So is the prosecution under common law or under admiralty?
We're not going to go in circles here. You have an obligation to be.
I'm just asking you.
I understand. My
right. Is it not my right to know the nature and cause of the charges?
Yep. I've answered you, Mr. Valentine. I'm not going to go in circles. You're in custody by Friday or post 10,000 cash or bond. We'll see you January 14th. That's all for today.
So why can't we go back to the original release conditions?
I've already made that ruling, sir.
and it was a void ruling. It's a void judgment.
So long, Mr. Valentine. We've talked. Be in custody by Friday or post your 10,000 cash or bond. We're done here.
So you're not going to honor your oath to
We're
uphold
done,
the
Mr.
Constitution.
Valentine. I'm honoring my oath and I've done exactly what I'm to do by state law and Constitution.
You haven't made
simply
clear the
disagree.
nature. You haven't
We're
made clear
done,
the
Mr.
nature and cause of the
Valentine.
charges, ma'am.
Please mute Mr. Valentine. I don't want him to say something that would be untoward for him. So we're done, Mr. Valentine. Turn yourself in by Friday or post your bond.
I'm not threatening you. Say one more word and that's 30 days. 30 days.